in this courtroom and in this building, I cannot have any attacks against people, or, you know, I don't want anybody yelling at other people in the courtroom. I don't want anything like that. If you do, I can hold you in contempt. So I know this is hard. I know this is hard for everybody in this courtroom, but we must behave, make sure to mind your decorum, and we don't want any issues, okay? So I have Allison Arnold appearing on behalf of the prosecutor's office. I have Michael Dagger-Margosian appearing on behalf of Ms. Steinwettel. This is file number 24-21814FH. Mr. Dagger-Margosian, along with the pre-sentence report, which I understand you would have received, I have received many victim impact statements and letters. Have you received all of those?
Your Honor, we've received a number of victim impact statements and we're ready to proceed.
Okay, can you move the microphone closer to you and speak up a little bit? All right, and were you able to review them with your client?
Yes.
And you received them as well, of course, Ms. Arnold, correct?
I have.
So, Ms. Steinwettel, have you had an opportunity to read and review the pre-sentence report?
Yes, I have.
Okay, and I'm gonna need you to speak up a little bit, all right, because we're recording. And have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, ma'am.
Are you satisfied with your attorney and the advice they have given you?
Yes, ma'am.
Mr. or Ms. Arnold, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Judge, I just have a couple minor corrections on page, it's the third physical page, which is labeled page 1 under evaluation and plan. It says that Ms. Steinwettel pled no contest to reckless driving causing serious injury. That should be changed to death.
All right, and let's see who this is Ms. Walsh. All right, let me see. All right, Ms. Walsh, you got that? Okay, all right, we will make that change.
And then if the court keeps going on page 6, I just noticed.
Physical page 6 or numbered page?
Go from 1 to 6 following that third page 1.
Okay.
And the employment, it says $475 a week, and then it says $700 a week. I just thought we should, whichever figure is correct, have that there.
Ms. Walsh, you're muted. I don't know if you have any information. Which one?
I would have to ask Ms. Steinwettel.
710 a week.
All right, 710 a week. We'll make that change.
And that's it, Judge.
All right. Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right. Ms. Arnold, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Mr. Dagger-Margosian?
No, Your Honor.
Probation Department computed the minimum sentencing guidelines to be 19 to 38 months. Do you agree with that computation of guidelines, Ms. Arnold?
I do.
Mr. Dagger-Margosian?
Yes.
All right. Now, I think we have 4 or 5 people that wish to speak today. Is that correct?
We do, Your Honor.
All right. So I guess I would like to take them first. Is that all right? So when it's your turn to come up, I'll have you come up to the podium and I need you can adjust the microphone and give me your first name and spell your first and last name for me before you speak, okay? All right.
Judge, first, we're going to have Elizabeth Moore, who is the sister of Elaine Christopher.
Okay. All right, I'm gonna step up to the podium. And if you can give me your first and last name and spell both for me.
Can you hear me?
You gotta speak up a little bit.
Okay, can you hear me now?
Yes.
Okay. Your Honor, my name is Elizabeth Moore, Elizabeethmoore. Eileen Christophers is my sister. Eileen was a wonderful, loving, patient, caring mother, wife, mother-in-law, daughter, sister, aunt, friend, and teacher. Her husband of over 30 years, Jeff, and her 2 boys, Scott and Matt, were her world. They came first in Eileen's life. Second was her job. Eileen gave her life to her job. She was a fabulous preschool special needs teacher for over 30 years. She gave 150% to her kids. On January 29th, 2024, Eileen went off to work like any other day, and she never showed. That's the same day that you, Madison, took her away from us. Eileen was 55 years young. She was looking forward to starting a new chapter in her life with her family. She was planning on retiring in 4 years. Her son, Scott, is now married, and she was so excited to have grandbabies. She told me in December, 1 month before she was killed in this horrible accident. And when she retires in 4 years, Scott and her daughter-in-law, Kay, could finally have babies because she would then be home to watch them. She would have been an amazing grandma, but Madison, you took those hopes and dreams away from her husband, and from her sons. Your Honor, Madison has had at least 7 prior violations involving her driving that I could easily find in 5 years. In October of 2019, she was charged with failing to stop an assured clear distance. Then in July of 2021, she was charged with speeding, going 20 over, at least 26 over. She was going 99 miles in a 55. In April of 2022, another speeding ticket, 85 and a 70. At this time, she was also charged with expired or invalid plates and no proof of insurance. In December of 2022, she was charged with driving while her license was suspended or revoked. Then last August, in 2023, she was charged with careless driving, where she was attempting to drag race that.
Judge, I don't know if it's appropriate for victim impact statements to go into this area. I generally don't chime in on stuff like this, but I'm not sure if this is appropriate.
Judge, I think it's appropriate. It's not offered for any factual, it's not establishing a fact like a pre-sentence investigation. These are the victim's feelings, and this is information they have that affects how they feel about the offense, and I think it's completely appropriate.
Well, some of that information is in the pre-sentence report, so I understand. I hear your objection, but I'm going to deny it. Thank you. Proceed.
And I'll skip the next one, okay? But you've gotten progressively more dangerous. And then you're charged with reckless driving, causing death. What will be next? Your Honor, Madison has continually received slaps on the wrist for all of these traffic violations. She clearly has not learned or just doesn't care. This horrific accident could have been prevented. I do not believe Madison shows remorse for what she has done. One day after the accident, a friend of Madison sets up a GoFundMe account. $657 were raised. The page then states, Madison is unable to do about everything. She will be going through a very long, hard road to recovery after surgery. It never mentioned she caused the accident or that she killed someone. It never mentioned to pray for the other person involved for their family. Madison, you lived, you can walk. And here she profited $657. The page is still up. I understand she did not put the page up, but she could easily ask her friend to take it down. Then in March of 2024, just a few weeks after the accident, she posts on her public TikTok page at that point, RIP cocaine train, with a picture of her truck. Someone posted under this post, rest in peace to the baddest truck out there. Madison, I hope you understand that you only lost a truck, an object, a possession, something replaceable. You took a loved one from us, a wife, a mother, a daughter, a sister, an aunt, and a friend from all of us. We never had the chance to say goodbye to or to see Eileen because of the damage that you did to her body. We didn't have that closure. You took that from us. Your truck was a weapon. Eileen never stood a chance with how massive your Ford F-350 was. Your Honor, I understand nothing can bring Eileen back. And no matter the amount of time Madison serves, will not be fair for taking her life. But I am asking you to sentence Madison to the full extent of the sentencing guidelines to help us feel like Eileen has had some justice.
Thank you.
Thank you.
Next, we'll hear from Katie Naveau, who is also Eileen's sister.
Step up to the podium, and then if you can state your full name loudly and then spell your first and last name, please.
Katie Naveau, Katie Naveau.
Thank you.
Your Honor, on January 29, 2024, I received the news that my sister Eileen was killed in a car accident on her way to work. Life has not been the same since. Eileen made good decisions. She put her husband Jeff of 35 years and her boys Scott and Matt first. She worked incredibly hard at her job, tending to the needs of her preschoolers. She worked tirelessly at home, writing IEPs, lesson plans, and planning for meetings. Her home was where she'd unwind, but she was still working. Whether she was cleaning, grocery shopping, fixing dinner, weeding, doing laundry, or helping the boys tear down drywall in their starter homes they were renovating, she was always working. Before she passed, we talked about getting our hair done, and she said, you know, I've never gotten my hair highlighted. I've never had a pedicure. I said, Eileen, we need to do that. She said she was always putting herself before herself. Eileen was 4 years from retiring. I too am a public school teacher, and the two of us were set to retire together in 2028. As much as she loved her job, she said she's ready. Life is truly not fair that someone like Eileen can go about her morning, prepare a crock pot full of stew, get in her car, head to work, and be struck and run over because someone decided to watch a TikTok video on her way to work. Today is the day, Your Honor, where you decide the sentencing for Madison. How much time does someone deserve for taking her life? Whatever you decide, it's never going to be enough. Eileen's not coming back. Coming from a family of 6 kids, I never had to worry about having too many friends because I always had someone at home to play with. Eileen was almost exactly a year younger than me. And now one of my best friends is gone. And while I miss her dearly, she's missing all the wonderful things that her family has done in just the past 10 months. She's missing the celebration of her son, Matt, who proposed to his girlfriend, Taylor. She's missing dress fittings and all the preparations for an upcoming wedding. She's missing Kaylin's announcement that she got into her master's program. She's missing the new renovation of Scott and Kay's house. But most importantly, she's missing making all those memories with Jeff, who was her best friend. She's missing all the rewards she worked so hard over the past 30 years of teaching. She was so close to the end of her career where she could finally slow down and enjoy the fruits of her labor. Not having Eileen here has left a giant hole in our family, and it's just not fair that she's not here. Thank you.
Thank you.
Next, we'll hear from Kay Christophers, who is Eileen's daughter-in-law.
Up there, you can adjust the mic if you need to.
Yeah.
What is your name, please?
Kaylin Christophers,
Can you spell your first and your last name?
KAYLYNN
Okay, thank you. Go ahead.
How do I turn down making a victim impact statement when the true victim in this crime cannot write one for herself? I almost did. There's a temptation to lean into self-preservation when our wounds have been reopened repeatedly by this process. But when I think about the fact that Eileen would be here fighting tooth and nail for any one of us, my choice is made for me. Giving an all-encapsulating message of the impact that losing her has had seems unattainable. Words are inadequate when the emotions are so strong. Thank you. that they are felt physically. However, I understand that now Eileen has to rely on her voice flowing through us to advocate for her. If it means that I've done what I can do to fight for her, I'll take endless reopen wounds for her. I'm doing this for the ones that can't, for every family member and friend that has shown up here consecutively for the last 10 months of court dates, and for the people who couldn't show up because it's all too painful. I'm doing this for you, Your Honor, in hopes that you can gather threads of who Eileen was through the people you've seen in here fighting for her time after time. I'm gutted that you don't get to meet her. I'm doing this for the girl who took the life of my second mom. I pray that what we're enduring as a result of your actions is the last catalyst for change that you will ever need. And most importantly, I'm doing this for my sweet, sweet mother-in-law. We had a relationship that most people dream of having with their own mothers. That I understand as a privilege. From day one of dating their son, Jeff and Eileen treated me like the daughter they never had. She used to call me that until eventually she just started calling me her daughter, which was arguably the cutest thing ever. She often told me that she couldn't have handpicked a better match for her son, to which I always responded that I hit the in-law jackpot. One time, Eileen actually did think she won the jackpot. She thought she won $40,000 on a lottery ticket, and I had to break the news to her that she read the directions wrong. Even then, she immediately got in her car and went to the gas station to turn in her winning lottery ticket. When she came back home, we asked her how big we had won, and she said we won $13, and I spent it on buying more lottery tickets, so we won 3. It's those silly moments that I'm so grateful I had with her in the 2.5 years I lived in Christopher's home. It's the simple things that I miss the most. The cups of hot cocoa she would have waiting for us when we returned home after a long, cold day at the house. The innocent and hilarious questions she would ask us while watching football, just to show interest even though she knew nothing about sports. And the forehead kisses before bed, which thankfully we all got the night before she was taken from us. We adored how simple she was. Her only cares in the world were her family, cute kids, finishing IEPs for those cute kids, shopping at antique stores, and taking walks or boat rides with Jeff. She couldn't wait for her own cute grandchildren. You'll have free healthcare or childcare as soon as I can retire, she would tell us. She was very much a quiet leader, one of those that led by her actions more often than her words. Rather than telling us to do the right thing, she would just do the right thing in front of us. It wasn't hard to learn how to be a good human from her. It is disheartening that she won't be here to live out her dream of having grandchildren due to someone else's inability to do the right thing. There's no doubt that Eileen taught us incredible things, but there are also some harsh realities I've learned as a result of losing her. I've learned that the world is unsafe. I've learned the feeling behind the word permanent. I've learned that bad things really do happen to the best people. I've learned the true value of appreciating time spent with the ones that we love, all the while knowing that at any moment we may not get any more. I've learned that 2 opposites can be true simultaneously, that I can feel anger towards the recklessness that took her life, while taking the opportunity to cherish the days we are given, rather than dwelling in the past. I've learned that I believe consequences are a necessity, and I've learned to allow the pain of my past and present to shape the gratitude of my future. None of this has been in our control from the start. On January 29th, 2024, it's like we were thrown into the rapids with nothing to hold on to, praying that someone could come along to help us stay afloat. It's like that, except what really happened is that on January 29th, 2024, Eileen was taken from us without warning. There's no way to get her back, and we're relying on a person of power and influence to take the control we never had and use it to make an adequate choice. to take a strong enough action to encompass anything close to the value of Eileen's life to us when the current laws diminish that. To help us stay afloat by providing us with the faith that someone's actions do carry the strongest of consequences, regardless of intent or the presence of remorse. Your Honor, though I don't envy your position in this, I ask that you handle the cards that we've been dealt with care, compassion, and liability. Thank you.
Mr. Overton, there's a box of Kleenex on that table. And could we perhaps pass a couple boxes back to the first row? Thank you. You can come up, sir. You can adjust the microphone, you're a little bit taller. Can you state your name for me?
Yes, Jeff Christophers, JEFF-CHRISTOFFERS.
Thank you.
I don't know how to start something like this, but I don't know how to express in a matter of minutes something that has been a cornerstone of, my life for so long, but it's brief. Not days and months, but years and even decades of my life, so I'm gonna give it a try. How am I gonna define Eileen, what she meant to us with the hope that it somehow makes an impact on the woman who killed my wife, on you, Madison, the hopes that this has an impact, not solely on us in this way that can empower us to move on, but empower you to change the momentum of what your life has carried over the past several years. And I'm just hoping this is an opportunity for you as well. I'm not asking for life to be devastated, but I am asking for the consequences of your actions to come to fruition today. And I'm obviously speaking to you, Judge, that I pray you see value in life, just human life, and understand that there's no possible way that the position you're in, you could have an intimacy with Eileen that we all had. There's no way. You do this every day, so you can't become calloused. I know that. I've watched you over the last months. I've been in here, I've seen compassion, but I've also seen control, and I've also seen the understanding that there are boundaries and consequences for people's actions. I'm hoping that's rendered today somehow, that same impact that you can have on a person's life, whether it's ours or Madison's. In reading this, I remember that I need to recall the way she was and not what she became. A body so devastated, so broken, that the coroner had never seen anything like it. The day of the accident, I begged the officers to just let me say goodbye to her. It's a physical thing, but it manifests itself in emotion, right? And I implored them to afford me, one last goodbye to her. Afford me one moment with her. I wanted to hold her hand or kiss her forehead for one last time. But with patience and understanding, they assured me that it just couldn't happen. They wanted to protect me like I had hoped to protect Eileen throughout her life. To this day, I've yet to say goodbye to her because I simply don't know how. So what do? I want to see her again. I want to see her today. My family needs me, but as I've said to you in earlier statements that you've received in earlier letters to the court, I'm just tired. I don't want to do this anymore. I mean, sure, I fake the smiles and do the dad jokes and attempt to stay busy with house projects. A lot of my friends and family, they see right through it, but they know that I'm going to love them with what I have left. Madison, I wrote this woman in here because I wanted to objectify you, but you are Madison. And you took it upon yourself to sentence Eileen to death. You also took it upon yourself to be judge and jury for the rest of us because we've been given a life sentence now. And I don't know how to get out. There is no parole for this. There is no probation for this. I'm deciding that this wasn't enough. Now I have to ask you, implore you, the court, to decide the value of Eileen's life. You've heard this from others. How do you do that? How do you quantify this? How do you qualify this? What it once was worth and what its future value would have been. It's not even just what she was, it's what she could have been. And including the grandmother that she just desperately so wanted to become. I can still picture her on the edge of our bed, her hands extended like she's holding our baby granddaughter, because she insisted on daughters, not the son she had. She insisted on the son she had. That's not fair, but she just so desperately wanted a daughter. She was that girl to me. And she's sitting on the end of her bed with her hands extended like she's holding our baby granddaughter while bouncing on her knees up and down. She's like, that's going to be me. And if you're nice, I might even let you hold her. I understand your hands are tied by the law, but please don't pale the life of such a beautiful person. It devalues her very existence. If Eileen had lived another 30 years, what would it have been worth relative to you, Madison? What would it have been worth to you? A year for a year? A month for a year? A week for a year? How does this work, right? Truly, this is a one-to-one. It should be. It isn't. It can't be. So help me do something for Eileen that I couldn't. It was my job to protect her in life. Emotionally, spiritually, physically, I failed. I just did. Speak for her. Speak for us and let us know she matters to you. Tell us that even in her passing, Eileen is still valued, because to some she wasn't even worth a 2-minute video. It's surreal sometimes. I have dreams about venturing on walks with her, holding her hand and relishing about how we stole an entire life together when others never find that true love. Still dreaming, because that's all I have these days. We celebrate our 70th anniversary together. We are in our 90s, slowly walking to nowhere, reminiscing about the last 35 years of a 70-year life that in reality we never had together, and bouncing the grandchildren she never had on those knees. Thank you. Okay.
There's nothing I say can convey the
Do
law.
we have, I thought we had more than,
No.
we don't have any more speakers? Okay, all right. Miss Arnold, is there anything you'd like to say on behalf of the people?
There is, Your Honor. Nothing I say can convey the loss to Eileen's husband, Jeff, her sons, Scott and Matt, her extended family, those future grandchildren, and the entire community. I urge this court to impose a sentence that's sufficient to deter Madison Steinwedel from any sort of conduct like this in the future, and that also deters the public in general from this behavior, because we've had way too many of these cases within Lenawee County. I hope Madison learns from this experience. Madison, I hope you learn, because you are still young, because your life was spared in this situation, which it very well could not have been. And I hope that you realize that every decision you make matters from here on out, that every minute of your life matters from here on out. And I hope you look to Eileen Christophers as a beacon, as an example of what your life can be after you pay your debt to society. And I hope you fulfill that sort of legacy. Thank you.
Yeah. Mr. Dagger-Margolin, could you and your client stand at the podium, please? Mr. Dagger-Margolin, is there anything you'd like to say on behalf of your client?
Your Honor, nothing, as we've indicated in this court, nothing said or done by anybody here is going to bring Ms. Christopher's back. on behalf of Madison, I want to extend our apologies and consolement to the family. This is obviously a very difficult day for everybody in this courtroom. I don't want that to be lost on anybody. From all accounts, Ms. Offers was a wonderful person. We didn't have the chance to meet her, but obviously she had a lot of family love and by all accounts was a very wonderful person. A little bit on Madison. I think it's important to highlight who she is and factors about her. She comes to you with no criminal history of any kind. She doesn't have any drug or alcohol use or abuse. There was no controlled substance or alcohol use on the date of incident. It was a complete lapse of an instantaneous lapse of judgment, which led to a life-changing experience for everybody in this court. I think it's important to note that Madison is gainfully employed. She does have family support here in the courtroom. She is loved by her family. She's paying a mortgage. She graduated high school. By many accounts, she is a good member of society. She's not a bad person. This was an extremely bad situation. It's hard to not be defined by the worst moment in your life, but I'm hoping that Madison, moving forward, won't be defined by this. She has more to offer for society, and obviously this court is going to impose a sentence which should accomplish things like what Ms. Arnold is discussing, deterrence, but also the other canons of sentencing are to be retributive, but also restorative, and that I know that the court will impose a sentence that does such. I want to highlight that this event was not done out of malice. She didn't have any ill will or ill intention. It doesn't excuse the result of it, but it does, I think it's important to note. Madison has taken responsibility and accountability in this matter by obviously admitting criminal guilt to this. We did conduct a restorative justice meeting with Ms. Christopher's family and some of the individuals who spoke today. It was actually the first one that I have participated in, and I wanted to set that up to at least begin the process of healing for Eileen's family, but also for Madison, because I think it's important for people to have a space to be heard, and I think that was accomplished at that particular meeting. Madison is beyond remorseful, but again, we cannot bring Eileen back, and that's something that Madison is going to have to deal with for the rest of her life. Madison has been cooperative in the entire investigation, as well as the court proceedings post-charge. It has been certainly a traumatic 10 months of this case existing. She hasn't driven since the date of incident, and part of this case was that we had discussed boot camp or known as SAI. It's come to both parties' attention as well as the courts that MDOC has their own internal policies, even though Madison is by statute eligible for SAI under 791.234A. She is eligible, but again, MDOC policy is just if there's a death in the offense, then that individual, I guess, won't be screened for boot camp. With that being said, I relayed that, and I think there would be grounds to withdraw the plea, and she said absolutely not. I'm taking responsibility. I don't want to put the family through more of this. So I think that should be highlighted as well. We agree the guidelines, we agree with the range. I'm asking obviously Madison comes to you as a young individual, 24 years old. Even the bottom end of the guidelines is a significant amount of time in prison, certainly for an individual of the factors that I listed to the court. I'd ask the court to, in taking all of the statutory and sentencing canons into effect, I'd ask the court to impose a sentence at the bottom range of the guidelines. Obviously, this court is free to construct a sentence that is appropriate, but that is our request at this time.
Ms. Steinmettle, is there anything you'd like to say?
Just want to say that I'm truly deeply sorry, and I'm going to take accountability to learn from my mistakes and move on. I know it can't bring her back, but I do want to say I'm really sorry.
Anything else, Ms. Arnold?
No, thank you.
Determining the appropriate sentence in this case, the court has to consider the seriousness of the offense, Ms. Steinwettle's history, the principle of proportionality, the statutory penalty, the class of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as all of what's been said upon this record. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication of law, and protection of society. This is probably one of the hardest sentencings I've ever done. Ms. Steinmettle, you are a young woman who is an absolute menace on the road. I don't think I've ever met anybody at your age with a history of civil infractions, traffic offenses that show just a complete lack of disregard for people on the road. I have an F-350 crew cab dually. I use it on the farm. I don't drive it on a daily basis, but it's a monster of a truck. And most people in this room have not driven a vehicle that big. But with driving a vehicle that big, there is a responsibility to pay attention. And you obviously weren't that day. And in fact, you were watching a TikTok video at the time the accident occurred, from what I understand from the prosecutor's office. So I'm a daughter. I have 6 children. My greatest fear every day is when my daughter leaves for school that she's going to get in an accident, because you know there's Tipton Highway and Hunt, and then you know any number of places my daughter can get into an accident, and that terrifies me. And she's 18 now, but I have 37-year-old children, and I still worry about them too. So Eileen Christophers was an amazing woman. I didn't know her, but she was deeply loved by everybody in this room. It's very clear. You are so fortunate, Miss, to have had a wonderful mother-in-law. Not everybody gets a wonderful mother-in-law. And so the fact that you can talk about her with love and respect and laughter is good. Mr. Christophers, you have never failed your wife, not one day in her life. Everybody in here knows how much you guys loved each other, and that love continues, whether she's gone or not. It looks like she was a woman of compassion and love. She cared for everybody. She was kind. She loved you all very hard. She taught and guided others to be their best. She would want you all to remember her with love. She would want you to heal and enjoy your life. I hope this brings you closure. But I can't put a price on her life. I can't. This isn't a civil case where there's like a $1.5 million settlement for the loss of a life. There's nothing, because her life was priceless. And so what a fortunate woman and what a lucky family you are to have experienced her love. I can only make sure that Madison understands, Ms. Steinbletto understands the consequences of her actions, and in the future works hard with children and teenagers and young drivers to make sure they don't make those same mistakes. The guidelines in this case were 19 to 38 months. As a judge, I am bound by the guidelines, and I have to determine what's in the best interest of all the parties. So the prosecutors represent victims, but they also have a responsibility to defendants. Defense attorneys have a responsibility to their clients, and they're going to both do the very best job they can. And we have wonderful attorneys sitting in this courtroom right now. I have to look at how to give you closure, how to make sure she's adequately punished. But I also have to take into account her age, her record. And I know you kind of started when you said she didn't have a criminal record. She has traffic violations. She doesn't, like I have other cases where someone was drunk or on drugs and driving and committed crimes, and the guidelines are actually higher for those, but that's part of the legislature and Michigan criminal justice committees. So, this is hard. This is hard for everybody in this room, and I can only hope that when you leave here today, you will slowly start remembering her with love and happiness instead of the hurt that you have now. And it will happen. I lost my dad a couple years ago, and it takes a while, but it happens. So, Ms. Steinbletto, it is the sentence of the court that you will be sentenced to the Michigan Department of Corrections for a period of 22 months to 15 years. You have 0 credit. You must pay a crime victim assessment fee in the amount of $130 and a victim or state cost of $68. As a term of parole, you will not operate a motor vehicle. You will also engage in community service and speak at victim impact panels in schools to talk about the dangers of distracted driving as a term of your parole. You do have the right, is there anything else, Ms. Arnold?
No, thank you.
You do have the right to appeal this sentence. My bailiff's gonna hand down to you your notice of right to appellate review. You're gonna initial and date 1 copy for our records. The others are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Did I forget something?
I wasn't sure about restitution.
I was just gonna add that.
Okay, Ms. Walsh, what is restitution?
It's $5,694.70. And that's to the crime victims compensation fund for the funeral costs.
Mr. Degemargosian.
I'm taking no position.
Okay, and I will order that in restitution as a term of parole. Anything else?
No, thank you.
All right, if you could initial and date that, please. And the other 2 copies are for you. As I said, if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Court's in recess. Of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that, Mr. Bomarito?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Mr. Bomarito, has your attorney promised you what your sentence will be like in terms of guidelines or the minimum sentence?
No.
Okay, and it's your own choice to plead guilty?
Yes.
And you're satisfied with her as your attorney and the advice that she's given you?
Yes, Your Honor.
All right, so Mr. Bomarito, on October 5 of 2024, were you at the Gus Harrison facility located in Lenawee County, Michigan?
Yes, I would.
All right, would you agree that that facility is located in Madison Township?
I believe it's located in Adrian.
Well, we call it Adrian, but it's actually located in Madison Township. Would you agree to that?
Yes,
Okay, and you were an inmate at that time at that facility?
yes,
And you had been sentenced and you were serving a term there, correct? So you were lawfully imprisoned?
yes, Your Honor.
All right, so at some point you came in contact with the Joshua Treyfry, who was an employee there. Was he a CO or was he a custodian? Like, what was his job there?
He was a CO.
Okay, and did you assault him in some way? Did you push him, pull him, kick him, punch him, spit on him? Tell me what you did.
I punched him, Your Honor.
You punched him? Okay. And you had no right to do that, correct?
No,
Yes.
no, Your Honor.
Okay, thank you. Okay. I swore you in, right, Mr. Bomarito?
Yes, you did.
Yeah, I did. Yeah, I did. I thought I did. Okay.
Sorry, Judge.
All right, Mr. Sneed, are you satisfied?
I am. Thank you, Judge.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood
It has.
and Mr. Sneed?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's agreement to the low end of the guidelines, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. So Mr. Bomarito, you're gonna get a packet. Someone's gonna talk to you. They're gonna prepare a pre-sentence report. Be truthful with them about your background, the events that occurred. They'll also look at your prior pre-sentence report. Ms. Underwood's really good about meeting with people within MDOC before sentencing, but sometimes MDOC won't let her schedule because they have other conflicts going on. So if she can't talk to you in advance, I will give her an opportunity to speak with you that morning. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Yes, I am, Your Honor. Mr. Bomarito is at Ionia, where they actually do let me schedule telephone conferences, Your Honor.
So Ms. Holly, he's at Ionia. All right, Mr. Bomarito, you do have a right to be present in person for sentencing, or you can appear via Zoom. What would be your preference?
I would appear via Zoom.
Okay, I promise you, we don't have as many cases on sentencing day, so it won't take as long. All right, so we will see you back via Zoom on that day for sentencing. And Mr. Bomarito, thank you for your patience this morning, and I'll see you back on that day. Thank you.
Can I ask you one question?
Sure.
Did you accept the Cobb's agreement or that's?
Yes, she did.
I'm gonna sentence you to the low end of the guidelines, whatever they are.
Okay. Thank you, Your Honor.
Thank you, Mr. Bomarito. You have a good day.
So,
Okay, Mr. Lee is next. So let me grab his file, put Mr. Bomarito's away. Okay, this is in the matter of the people of the state of Michigan versus David Edward Lee Jr., file number 25-22195 FH. I have Rhonda Underwood appearing on behalf of Mr. Lee. I have Isaac Sneed appearing on behalf of the people. This is date and time set for it looks like the first pretrial in this matter. So, Ms. Underwood, how would you like to proceed with Mr. Lee today?
Can I speak to Mr. Lee for
Yep.
just a second, Your Honor?
So, Mr. Lee, I am going to pop you in a waiting room. We also have really good audio on Mr. Lee today. So, go ahead and join that breakout room. He went automatically. Mr. Sloan will be right with you. Miss Adams, I don't know how, but we're gonna have to send notice or advice rights forms to Mr. Lee and Mr. Bomarito to get
Okay.
that signed.
Are those the same ones used in district court?
No, they're the circuit court one.
If they make a packet up, they take it to the jail, or they can just hand it to them.
Yeah. Yeah, so that would be great. So Ms. Adams, Deputy Lucy will talk to you because I think we can send a packet over to the jail. Good morning, Mr. Dagger-Margosi.
Morning, Your Honor.
You have someone from MDOC. So are you done down in Judge O's?
I'm all done. I just have Mr. Oliveris here.
So we have Mr. Sloan, and so he'll be after.
Okay, thanks.
All right, Ms. Underwood, I will bring your client back. Maybe. And Rhonda Underwood, I have a million pickups this morning, so I'm gonna apologize in advance. Hi, this is Judge Anslon. So it looks like I have a bunch of pickups this morning. I have Mead Byers. I have, what's her name? Samantha Ladd and Angelina Hall. And I know they're on your floor, so I'm ready to see them whenever you can.
Okay, and then I do have a question for you.
And I may have an answer for you.
Mr. Marvin, I got a pre-sentence commitment from you guys this morning. And it says bond continued, but we don't have him here on this charge. So should I be setting him a bond?
So you're asking the wrong person.
Oh.
That would be Becky. Because I don't have his file anymore, so I don't know.
All right.
Becky does the paperwork, so she'll help you with that.
All right, thank you.
Bye. Of my pay grade. Okay. Okay, so we're back with Mr. Lee. Ms. Underwood, how would you like to proceed with Mr. Lee?
Your Honor, the plea bargain offered to Mr. Lee is as charged, and the habitual 4 supplements will be dismissed. I would also be requesting a COBS to the low end of the guidelines in this matter, Your Honor.
So plead guilty as charged to count 1 and his habitual offender 4th notice dismissed. Mr. Sneed, 1, is that a correct recitation of the plea? And 2, do the people take any position on a COBS to the low end of the guidelines?
Your Honor, yes, it is correct, and we would defer to the court regarding the sentence.
All right, thank you. All right. So, Mr. Lee, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, and state your full name for the record?
David Edward Lee Jr.
Thank you. All right, you can put your hand down. And I apologize, I may ask you to speak up a little bit louder just because you're kind of soft-spoken to begin with. So Mr. Lee, you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison The habitual offender notice will be dismissed and there's a Cobb's agreement to sentencing to the low end of the guidelines. So is it your intention to plead guilty to that today?
Yes,
All right. Are you satisfied with your attorney and the advice that she has given you?
completely.
Good. Now, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the Cobb's agreement to the low end of the guidelines. Is that correct, Ms. Underwood?
It is, Your Honor.
Mr. Sneed?
Yes, Your Honor.
And Mr. Lee?
Absolutely.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Lee?
Completely.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
Can you repeat that?
Yeah.
Is that
Yes.
a yes? Okay. You're kind of faint, and so we have to record this, and so I didn't pick that up. So, Mr. Lee, do you understand that if the plea is accepted and you engage in any misconduct as defined under MCR 6.310 between now and sentencing, the court will
Yes, sir.
not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. So if you were to commit a new criminal offense, the court wouldn't be bound to that Cobb's to the low end of the guidelines, and you wouldn't have a right to withdraw your plea because of that. Do you understand that?
Yes, I do. I've got one
Okay.
question though.
Yes, sir.
Not saying I'm gonna do it or anything. I'm not saying that at all, but is attempted suicide a crime now?
I would, okay, so one, Mr. Lee, don't do that. Okay, but
Just ask,
that would not be a violation of this, no.
okay.
But
I
also,
wanted to,
don't do that.
I won't, I won't. Trust me, I won't. I just
Okay,
wanted to
good.
know because sometimes I go through ups and downs and I don't take my medication sometimes and it just screws
Okay.
with my head.
Well, take your medication. It's, you should take your meds, okay?
Of course I should.
Okay. What was the last thing?
Your Honor,
Huh?
You were explaining to him about that.
Okay.
I'm a little concerned. Mr. Lee's statement has made me concerned as
Why?
to Mr. Lee,
Yeah,
I very much understand you want to get this over with today.
yes, I do.
Much did.
Don't-
However,
don't-
I'm concerned by your last statement that maybe we need to have you checked out by the doctors.
No, because I go through the doctor's shit all the time. I talk to the
So,
doctor.
Mr. Lee, let me ask you a couple questions. Are you currently taking your medication?
Yes, I am. I just wanted to know for further reference, just in case I might go through one of those pitfalls.
Okay, so right now you feel that you are stable medically and mentally, correct?
Yes, completely.
But you're concerned that one day in the future, if you weren't compliant with your meds and you had suicidal ideations, that could be a violation.
Yes, that was my concern.
Ms. Underwood?
That's it.
Mr. Lee, do you understand what we are doing here today?
Yes, I do. I have complete and utter cognizance right now. I am completely lucid.
And you understand my job? You understand the judge's job?
I understand all y'all's job.
Okay,
Prosecutor,
okay.
I'm stupid.
Thank
I
you,
just,
Mr. Lee. Miss Underwood just has to make sure, okay?
I had a concern with how my moods are sometimes.
Okay. Well, and you should always voice concerns and questions if you have them, okay?
Yes,
Your Honor,
please don't know how I am.
I think that Mr. Lee does not demonstrate incompetence to me today.
Okay.
He demonstrates
Be confident.
perhaps
I'm completely
mental-
confident.
Oh, we're good. Everybody, we're good. We're good. Mr. Lee, we're all good. Miss Underwood, thank you. Miss Underwood just needed to make sure. So I appreciate that she took the time to do that. So, Mr. Lee, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes,
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
yes, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you today, Mr. Lee?
No, I asked the only question that I had.
Excellent. All right, so Mr. Lee, how do you wish to plead to the charge that on or about October 4 of 2024 in Madison Township in the county of Lenawee at the Gus Harrison facility that you did commit the offense of assault of a prison employee? Guilty or not guilty?
Completely guilty.
All right. So has anyone made any threats or promises to you to induce you to plead guilty to this charge?
Absolutely not.
Do you understand that if I accept this plea, you will be giving up any and all claims that, okay, and your attorney hasn't promised you any particular sentence or estimated what your sentence will be, Mr. Lee, has she?
No.
Okay, and it's your own choice to plead guilty?
Yes, it is. It's my, I want to do this as soon as possible.
Excellent. All right. So, Mr. Lee, on October 4 of 2024, were you incarcerated at the Gus Harrison facility?
Yes, I was.
Say that again for me.
Yes, I was. I came in contact with an officer, Tenniswood, and we.
Oh, hold on, Mr. Lee. You got to only answer my question as we go, because I got to make sure I get the elements. So on October 4 of 24, yes, you were incarcerated at Gus Harrison facility.
Yes.
Okay, and you were incarcerated there due to being sentenced on a crime. So you were lawfully incarcerated at that time, correct?
Yes, I was.
And would you agree that the Gus Harrison facility is in Madison Township in the county of Lenawee?
Yes, it is.
All right, now you mentioned Brian Tenniswood. He was an employee there. Was he a correction officer? What did he do there?
The correctional officer.
Okay, and at some point you assaulted him. So did you push him, punch him, kick him, spit on him? What did you do?
I elbowed him in his chin. No, in his cheek.
You say that again. You elbowed him. Where did you elbow him?
In his cheek.
In his cheek. Okay. All right. And you knew he was an employee of the Gus Harrison facility, correct?
Yep.
All right. Mr. Sneed, are you satisfied?
Yes, thank you, Your Honor.
Has court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I am going to refer this matter to the probation department for a pre-sentence agreement or a pre-sentence investigation. This court has made no agreement other than a COBS to the low end of the guidelines regarding any other possibility of a plea or possible sentence. In this case, with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Your Honor, the only thing I would say is it's shaping up that I'm having a lot of sentencing that day, both here and down the hall. Can we go a
Ms.
week
Adams,
later?
can I move that out one more week, please? Or to the next available sentencing date?
Yeah, let me see. It would be Friday, July 18th.
All right, so Mr. Lee, I'm going to set this for sentencing on July 18 at 8:15 in the morning. Where are you currently incarcerated?
He's in Ionia, Your Honor.
I asked him, what'd you say, Mr. Lee?
Ionia Correctional.
Excellent. All right, Mr. Lee, you do have the right to be present in person. Do you want to appear via Zoom or in person? I promise you won't wait as long on a sentencing day. We have less cases that day, so we're able to get you in and out. But do you want to appear in person or via Zoom?
I'll deal with the Zoom.
Okay, so I'll mark that down for via Zoom. Mr. Lee, someone's gonna reach out to you and do a pre-sentence report. Be truthful with them about your background, the events that occurred, and then we will see you back via Zoom on that day. Miss Underwood is really good and Ionia is really good about letting her talk to you in advance. So she will review that pre-sentence report with you. If for some reason, like maybe they're on lockdown or something's going on and she can't meet with you, I will give her a chance to speak with you that morning. So I will see you back via Zoom. What, Mr. Lee?
I have a question.
Okay.
Is it necessary that I go through the pre-sentence investigations process?
It is, we're required by law to do that. I mean, you don't have to take part in it, but usually it's just you filling out a packet. So they'll look at your prior. Huh?
I'm not gonna fill the packet out.
Well, that's your choice, sir. So, Mr. Lee, we're also going to mail to you an advice of rights form that goes through the rights that I gave you today, and they'll have you sign that, and that'll get sent back to us, okay?
Okay.
All right, Mr. Lee, thank you for your patience today. You have a good day.
They were very taxed.
Yeah, I know. All right, have a good day, sir.
You too.
All right, Mr. Sloan, in the matter of the people of the state of Michigan versus Daniel Robert Sloan, we have two files, 24-22044FH and 24-21690FH. I have Rhonda Underwood appearing on behalf of Mr. Sloan. I don't even know what you're here for. Hold on, let me back up a little bit, find you. This is the date and time set for pretrial on a probation violation on both of these files. I have Rhonda Underwood appearing on behalf of Mr. Sloan. Miss Underwood, how would you like to proceed with Mr. Sloan today?
Could I speak with Mr. Sloan for just a second, Your Honor?
Yes. So I'm going to open up a breakout room and I'm going to put Zoom 2 and Miss Underwood into that breakout room. Very good. All right. So, Mr. Oliveras, good morning.
Good morning, Your Honor.
All right. This is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. We have two files, 24-21891FH and 24-21892FC. I have Michael Dagger Margosian appearing on behalf of Mr. Oliveras, and I have Dave McCready appearing on behalf of the people. This is the date and time set for pretrial. So, Mr. Dagger Margosian, how would you like to proceed with Mr. Oliveras today? Looks like we have a jury trial scheduled for May 14 at 10:30 a.m.
Judge, it's a bench trial. We had adjourned this case for us to get the preliminary exam transcript. We do have that transcript now, so we're ready to proceed next week.
Okay, so we are ready to proceed to trial. Anything we need to address today, Mr. Dagger Margosian?
Not from defense, Your Honor.
Mr. McCready?
People are all set.
All right, so Mr. Oliveris, I'll see you back on that day for a bench trial. Thank you.
Can I get a breakout room, lawyer, please?
Do you have time, Mr. Dagger Margosian?
Of course.
Okay, all right, I am going to open up a breakout room, jail Zoom 3. And Mr. Dagger Margosian, there you go. Go ahead and join that breakout room. All right, Mr. Byers, good morning.
Good morning.
This is in the matter of the people of the state of Michigan versus me, Jonathan Byers. Mr. Byers, I do have a request and summons for probation violation that was filed by the District Court Probation Department, which alleges that on I'm sorry, this is file number 23-21531FH. So, Mr. Byers, the allegation is that the Michigan State Police called the probation department and reported that you had submitted a PBT result of 0.051. You have probation terms for no alcohol, and the probation department advised they could lodge on a probation violation. And bond was set in the amount of $5,100, which is what I'm assuming is left owed maybe on that file. So, Mr. Byers, you do have a right to have an attorney represent you on this and all subsequent case hearings. Would you like an attorney appointed to represent you?
No, thank you.
Okay, so hold on 1 second. Their probation terms, so hold on, it takes me a minute to find them.
I actually had court on it's either the 13th or 15th with you to just wrap up my probation. I paid off all my fines. I paid off the remaining $1,066. So really all I had to do was just show up and be off probation, but then I had this happen. But I plan on just pleading guilty to it.
Hold on. Don't say anything yet. Hold on 1 second. I gotta figure out, force and safety.
There's a recommendation on the back of that, Judge. I don't know if you've seen.
Reach the voicemail, Mike McCarran.
Mr. Byers, you know you have a right to an attorney. Are you waiving your right to a court-appointed counsel?
Yes, ma'am.
All right, Mr. Byers, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. Byers, you understand that technically you're on probation for MDOT less than 200. So if you plead guilty or found guilty, I could give you up to 93 days in jail. Do you understand that?
Yes, ma'am.
I do have notes that you have paid everything in full. So, Mr. Byers, at this time, I'm going to dismiss the violation of probation. I'll give credit for time served. I'm revoking your probation. All right.
Okay, thank you.
Mr. Byers, stop doing stupid stuff and make better choices. All right.
Yes, ma'am, absolutely.
All right. Thank you.
Do I still need to appear on the 16th? Because I had court with you on the 16th already. It was pretty much
No,
just
you paid everything off according to the probation department, so we're all set. All right.
All right.
All right.
Thank you very much.
Thank you.
Bye.
So,
So am I like good to go today, or do I gotta have to stay in
yeah,
jail?
you're
or-
done. You're done with me unless you got new charges. I don't know, but my case, I'm done.
No. Okay, all right, thank you.
Thank you. All right, so we're back with Mr. Sloan, Miss Underwood. How do you wish to proceed with Mr. Sloan? Do you waive the reading of the felony information?
I
Or wait,
believe
no, it's
this is-
probation violation. Never mind. So how do you wish to proceed with Mr. Sloan?
Mr. Sloan is going to plead guilty to this violation, Your Honor.
Right, Mr. Sloan, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Sloan, you've heard your attorney. Is it your intention to plead guilty to these violation of probations?
Yes, ma'am.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
Trying to get to the violation of probation. Okay, so the allegation against you on both of these files is that you violated your articles of probation and that you failed to report to the Lenawee County Probation Department the following Tuesday upon your release from jail, and then you failed to report any time thereafter. Do you understand those are the violations against you?
Yes, ma'am.
On file number 24-22044FH, if you plead guilty or found guilty, the maximum penalty for larceny in a building could be up to 4 years in prison. Do you understand that?
Yes, ma'am.
And then on file number 24-21690FH, you're on probation for possession of methamphetamine. So the maximum penalty for that offense could be up to 10 years in prison. Do you understand that?
Yes, ma'am.
All right, now you do have a right, let me get back there. Sure, yep. Okay, so do you understand that you do have a right to have a trial on this matter and to contest the violation of probation charge?
Yes, ma'am.
Okay. You have a right to have that throughout the trial you would be presumed innocent until your guilt is proven by a preponderance of the evidence. You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you could ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify? Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty, you will be giving up your right to a trial, as I've already explained to you?
Yes, ma'am.
Has anything been promised to you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand all of that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Sloan, on both of these files, you were sentenced, and one of the terms is that you were to report to the probation department the following Tuesday after your release from the Lenawee County Jail. Is that correct?
Yes, ma'am.
And did you report to the probation department on that day?
No, ma'am.
Did you report any time after that?
No, ma'am.
Did you call them?
No, ma'am.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this matter for sentencing on May 15 at 8:30 in the morning. Is that day acceptable to you, Ms. Underwood?
It is, Your Honor.
All right, so Mr. Sloan, someone will be come over and meet with you, and they'll prepare a pre-sentence report. We'll provide that to Ms. Underwood. She's really good about reviewing that in advance, but if she's not able to, I'll give her a breakout room to speak with you. Do you want to appear via Zoom or in person?
Via Zoom.
Okay, so that'll be via Zoom. All right, thank you, Mr. Sloan. You have a good day.
You as well, ma'am. Thank you.
All right, thank you. All right, so Miss Ladd, is that you?
Yes, ma'am.
All right, let me grab your file. It's like Mr. Dagger Margosian's still talking. Maybe, oh, okay, so this is in the matter of the people of the state of Michigan versus Samantha Diane Ladd. We have two files, 22-20962 FH and 23-21239 FH. Ms. Ladd, we are here on a request and warrant for probation violation, which alleges on each file multiple violations. One, that on April 17th of 2025, you were in possession of methamphetamine when you were positive for methamphetamine and marijuana. The second allegation is that on or about April 17th, you were tested positive for okay, so I have one, you tested positive on April 17 for methamphetamine and marijuana, and on April 24th, you tested positive for marijuana. And then on April 18th, you failed to notify the probation department that you changed your address. The next allegation is you have not been employed since being fired from McDonald's on or about January 15 of 2000 and, is that 21, Ms. Walsh?
23.
20, should be 25.
24.
25.
25, so I'll make that change. You can amend that. And then the next allegation is that you have not made any payments towards your court costs or supervision fees. The next allegation is that you have not engaged, hold on, Ms. Ladd, I'm talking. You have not been engaged in services to obtain your GED or high school diploma since May of 24. And then on April 18th of 25, again, another allegation that you're in contact with Joseph Garcia when he violated his bond conditions for domestic violence. So those are all the allegations against you. Now, on file number 22-20962 FH, if you were to plead guilty or be found guilty of these offenses, you are facing a maximum penalty. Miss Walsh doesn't put the max penalties down for me. So let me see, this is 22. So possession of cocaine, the maximum penalty is up to 4 years in prison. What's the max penalty on use of methamphetamine? Is that a 1 year? I don't have the file, Ms. Walsh, I apologize.
What docket? I'm sorry.
On 22-20962 FH shows count 2 as controlled substance. Is that use of cocaine or methamphetamine? That would be a 1 year misdemeanor, right?
Yes.
So Ms. Ladd, those are the maximum penalties on that file. And then on file number 23-21239 FH, you're on probation for assault with a dangerous weapon, and the maximum penalty on that file could be up to 4 years in prison as well. So Ms. Ladd, you do have the right to have an attorney represent you on both of these files on the probation violation and any future hearings. Would you like an attorney appointed to represent you?
Yes, ma'am.
Now, Ms. Ladd, I know that you were taken into custody today. Are there any pending charges from that incident, Ms. Walsh, that you're aware of, or violations?
I'm not sure. She did run from our office, ran from office deputies. I'm not sure.
Okay, so Ms. Ladd, are you currently, and I need to know this truthfully because it'll impact what we do today. Are you under the influence of anything that would impair your ability to understand the proceedings here today?
No, ma'am.
All right, would you like an attorney appointed to represent you?
Yes, ma'am.
All right, Ms. Underwood, I am going to appoint you to represent Ms. Ladd. she's previously always had court-appointed counsel, so I do think she qualifies for court-appointed counsel. And I am going to open up that window and go ahead and join the breakout room. Okay, so that's that one. We have a couple more. All right, Miss Innings and Mr. Biggs, it'll just be a minute. I apologize.
No problem, Your Honor.
Thank you, Judge.
Do you guys want a breakout room?
No, we already spoke, Your Honor, this morning prior to zooming in.
Okay, yeah, we had a lot of new arrests. It's a review, so will it take long?
No, I don't think so, Your Honor. There's just a couple things I have to say, and honestly, I don't think there's.
What started as a family day at the beach quickly turned into a violent courtroom case involving gunfire, a pistol whipping, and 3 young children caught in the middle of the chaos. During this preliminary examination, prosecutors laid out shocking allegations against the defendant. According to the witness, he and his family were spending the afternoon at the beach when tension suddenly developed between the defendant and his girlfriend. After learning about the confrontation, the witness approached the defendant simply to ask why he was trying to start an argument. But according to his testimony, the situation escalated almost instantly. He told the court that the defendant pulled out a handgun, fired 2 or possibly 3 shots, and then leaned over from his boat and struck him in the face with the firearm. The witness described being hit on the left side of his face, near his temple, leaving him swollen and in pain. Even more alarming, he testified that the shots were fired toward the beach, where several people, including 3 little girls, were nearby. Prosecutors later showed photographs of the injuries, and the witness confirmed they accurately reflected what happened immediately after the incident. The defense challenged nearly every part of that story. During cross-examination, defense counsel questioned the witness about his relationship with the defendant and suggested there was more history between the two than the prosecution had revealed. The attorney also questioned why the witness didn't retreat if someone had supposedly fired a gun. According to the defense, the witness admitted that after the alleged shots were fired, he stayed near the defendant's boat instead of backing away. The attorney suggested that his actions didn't match someone who truly feared for his life. At several points, the questioning became tense enough that the judge had to step in. The judge reminded the witness not to interrupt the lawyer, instructed both sides to slow down, and insisted that questions be asked one at a time instead of combining several questions together. The courtroom became increasingly heated as both sides argued over exactly what happened during those critical moments at the beach. After hearing testimony from both sides, the judge explained that his job at this stage wasn't to decide who was telling the truth. Instead, he only needed to determine whether enough evidence existed for the case to move forward. The judge ruled that there was sufficient evidence supporting the charges of felonious assault and felony firearm,